Welcome back, everyone. Ladies and gentlemen, we will now proceed for the first panel discussion of the event on the theme Banking and Industry Perspective on IBC. For this, I would like to introduce the panelist of the day, Shri M.B. Gosavi, Honorable Member Judicial, National Company Law Tribunal, Ahmedabad Bench, Shri B. Shri Ram, former Managing Director and CEO, IDBI Bank, and part-time member of Governing Board of IDBI, Shri Shardul Shroff, Chairman, Shardul Amarchand Mangaldas and Company, Shri Sunil Mehta, Chief Executive, Indian Banks Association, Shri Partha De, Senior General Manager, ICICI Bank. So we look forward to hearing from you.
Thank you. Good morning, everyone. All scholars, my honorable panel members. We are speaking about banking and industry perspective on IBC. In fact, we were just speaking that someone should be from industrial field ought to have been here because it could have been more fruitful with that as advertisement. In fact, I will give keynote address within 5 to 10 minutes, and then I will throw the subject for discussion, the points therein. I must confess that I am not good orator. Otherwise also, if we judges are paid for listening and not for speaking, as you know. Because in the court, professional and advocates speak, we hear. In a society, we give some orders and society speaks, media speaks. We have no role to speak there. And in home, it is our experience that we have very less role to speak even at home. So speaking is not my area. Still, I will give some few points for deliberation. In fact, this topic, I don't know why I have been chosen as a chairperson here, because topic is perspective, banker's perspective, industrialist's perspective about the insolvency and bankruptcy code. In fact, I being adjudicating authority under IBC, exactly I do the same job that banker's perspective before me, the industrialist or corporate debtor's perspective before me about entire material placed, and I have to decide whose perspective is correct. And so, as far as my speaking is concerned, that way may not be having much relevance. This matter is concerned. Insolvency and Bankruptcy Code 2016 is that way it is very welfare legislation brought about, because it is basically meant to make stand the corporate debtor on its own feet. I will be giving, I wanted to impress that whether default committed by person can be said to that person is insolvent. Default can be for any reason, but thereby now we have taken away that. Formerly, when matters were being considered under the liquidation in winding up proceeding, there was a specific finding has to be given that now person is or industry is insolvent, not able to pay. But here, only one default, that too more than 1 crore, we have to declare that entire empire is insolvent. Whether some changes are required to this. Secondly, that 1 crore default amount is fixed 1 crore as per section 4 IBC. The industry worth more than 10,000 crore could not pay for 1 crore for number of reasons, and that to operational creditor, service provider. There are number of reasons. They could not have raised any dispute. Whether we should push that to insolvency, and we should suspend the board of directors who has set up that empire by burning the blood. That also we have to consider, because one of the objects of the insolvency is to promote the entrepreneurship, to enhance the credit rating, that too in time-bound manner. While doing so, we have to balance the interest of all stakeholders, and everything has to be done within maximum period of 330 days. But when we speak about perspective of bankers is concerned, it is interesting to note that how implementation of IBC 2016 has impacted banking and finance business. Reserve Bank very recently, the apex body controlling banking, has advised time and again to the bankers, you don't wait for specific instructions, approach NCLT or adjudicating authority as early as possible, because it is our experience that time, assets, the value of the assets get reduced because of lapse of time. RBI in report has noted the trend and progress in banking industry and said that lenders should use IBC to maintain the quality of their books. It is the experience of banks that by taking route of IBC, Insolvency and Bankruptcy Code, it had helped them to clean up their balance sheet, at least to some extent. The practice of dragging lenders to the court to delay the payments of outstanding loan is slowly coming down. That change has been occurred now. That is, we could experience that. And now India has become more attractive an investment destination. The framework of IBC has instilled the credit culture in borrowers. The hundreds of industrialists and borrowers have come forward voluntarily for settling the outstanding loan extent of $40 billion in order to avoid danger of being dragged under the IBC. Now it must be said that it is a deterrent effect of this law as far as business houses are concerned. In this keynote address, I will give honorable panel members some points, whether they to deliberate upon, whether the Insolvency and Bankruptcy Code provide quick resolution of stressed assets because of corporate insolvency resolution process is a time-bound program for maximum 330 days. As against restructuring scheme provided by RBI in form of SDR, etc., was being used for avoiding downgrading rather than resolving the distress. What is what we should think about this? Second, whether the IBC acts as an instrument to drive the banks to refer specific cases for default or resolution, and what is the success rate as far as banks are concerned. Whether Insolvency and Bankruptcy Code brought about a change in equation that earlier recovery mechanism was a debtor-centric and now it has become a creditor-centric, which has been internationally accepted in insolvency process, whether we have succeeded in achieving this. Fourth, Insolvency and Bankruptcy Code provides both creditors and debtor power to initiate proceeding under IBC 2016. The formation of Insolvency and Bankruptcy Code 2016 demarcate judicial aspect and commercial aspect clearly. It has narrowed down the adjudicating authority's role to facilitate. Role of adjudicating authority is to only facilitate the due process of law. It has no role to decide controversies arising out of, because it is for the committee of creditors and other stakeholders to decide. Now, inclusion of non-banking financial institution in Insolvency and Bankruptcy Code has provided such a large creditors the route of insolvency, resolution of stress assets, because earlier they have to take only route of liquidation or winding up. There was no other route. In fact, report of review committee of RBI of working assets of reconstructing the companies has made recommendation that assets reconstruction companies should be allowed to take part in IBC proceeding, either directly or providing some other ways. It has been revealed from the study data collected from ARC's performance that recovery rate is encouraging one. It is so because under SURFACI Act, I suppose section 2 subsection 10 says that assets reconstruction company cannot do any other business, that is putting the plan, etc. That has to be corrected too. Insolvency and Bankruptcy Code 2016 has also impacted on stock prices of some of the banks, Indian banks. It has not just reduced their non-performing assets, but has improved their share prices considerably. It has instilled the better credit discipline, sense of urgency and seriousness amongst the defaulting borrowers. Nearly 2.2 lakh crores rupees of debt settled relating to 4,452 cases referred under IBC. Even prior to admission of the cases under IBC, number of borrowers settled the dues, resulting good recovery. Insolvency and Bankruptcy Code 2016 proved to be game changer in Indian banking and industrial sector. It has been established that the banks, financial institute and other creditors could recover more than 1 lakh crore through IBC route at the end of year 2019. Now recovery rate has been somewhat reduced due to pandemic and other reasons. In fact, Parliamentary Committee, Standing Committee's report on finance implementation of Insolvency and Bankruptcy Code, pitfall and solution, that is 32nd report published on 3rd August 2020. It has been observed that the information furnished by Ministry of Corporate Affairs revealed that Indian resolving insolvency rank improved from 136 in the year 2017 to 52 in the year 2020. The average time taken for resolution has been reduced from 4.3 years in the year 2017 to 1.6 years in the year 2020. Indian rank in ease of doing business improved from 155 in the year 2017 to 63 in the year 2020. Getting credit rank improved from 151 in year 2017 to 136 in 2020. While taking into consideration impact of pandemic on the implementation of the code, the committee finds that low recovery rates with a haircut as much as 95% and delay in resolution process with more than 71% cases pending for more than 180 days before adjudicating authority clearly points out the deviation from original objective of the code intended by the Parliament. The committee therefore feels that design and implementation of code as it has evolved needs to be revisited, particularly in light of original aims and objectives. It has been also observed by the Parliamentary Standing Committee that power of Committee of Creditors is a question before the forum due to high quantum of haircuts and on the basis of commercial wisdom. It is expected that government in consultation with the banks may come up with some mechanism to discourage huge haircuts as it is seen as foregoing huge taxpayers' money. It has been suggested in the report that although commercial wisdom of COC is a supreme, but there needs some checks and balances to regulate the same. It has also been observed that COC replaces interim resolution professional. That is our experience, day-to-day experience while working as an adjudicating authority. That Committee of Creditor replaces interim resolution professional by appointing new professional as a resolution professional of their choice without any guidance. It is now need of the day that entire CRP has to be in more transparent manner. Honorable Supreme Court in very recent ruling in India Resurgence ARC Private Limited versus Amit Metallics Limited took a note of commercial wisdom of COC once again and said that NCLAT was therefore right in observing that such amendment to Section 4, which has been recently amended in 2021, of Section 30 only amplifies the consideration for Committee of Creditors while exercising its commercial wisdom so as to take an informed decision and regard to the viability and feasibility of the resolution plan with the fairness of distribution among similarly situated creditors, and business decision taken in exercise of commercial wisdom of COC does not call for interference unless creditor belonging a class being similarly situated of denied fair and equitable treatment. However, in regard of various resolution plan put for approval of the adjudicating authority, recently question regarding approving resolution plan with high haircut and value offered in a plan being less than liquidation value has again arisen. The most latest judgment of NCLAT given on 19 July 2021, NCLAT had stated the NCLT's judgment dated 8 June 2021 approving resolution plan submitted by Princeton Technologies in CIRP of Videocon Group. It was argued that haircut of 90 to 96% has been taken and amount of resolution plan is though very close to liquidation value. In this connection, fair value and as well as liquidation value of the corporate debtor assets plays a vital role. The valuation is carried out as on insolvency commencement date by two registered valuers helps the member of COC to decide on financial offers. However, in most of the cases, valuation of assets arrived at its low compared to the claim admitted. In my considered opinion, following may be reasons for haircuts in resolution plan. One, that large time taken in deciding to file application and then getting corporate debtor admitted in CIRP. Second, mismanagement including instance of preferential, undervalue, extortionate and fraudulent transactions. Three, information asymmetry that includes book of account, not complete and proper record. It is not available or it is missing oftenly. 3, market condition not conducive with limited demands. 4, financial market of states assets yet to be developed in India. Next, legal issues takes long time and hampers timely approval of and implementation of resolution plan. And following are the suggestion for this, which I put. Issue regarding haircut and resolution plan having wide ramification. Any adverse finding could lose the spirit of code. Necessary safeguards and transparency need to be built up, insisting so the objective of the code being achieved too. The present practice of that all resolution plan issued by RP are deliberated and negotiations are held by members of COC, but COC members do not disclose the reason for approval of the plan. So it is necessary to impress upon COC to disclose the justification as to why the particular plan was approved, though it is having higher haircut. In my considered opinion, it may not be in conflict with the principles of commercial wisdom of COC, which is said to be supreme. The expert panel may be drawn from professional, from industries, from valuation expert, from accounts and auditing field, and also from legal field, so as to provide their views on a such matter. The market of stress assets need to be widened and necessary policy changes are required at the RBI's level. The operational efficiency at various levels needs to be emphasized. It has to be noted that recovery rate of financial creditor has fallen to 36% as of June 2021 from 45% as to March 2022. A classic case of Ghotaringa Minerals and Orchid Healthcare, which was having debt of 8,163 crore, though they have no assets when they were entered in process IBC 2016. In such situation, creditor have no option but to take 100% haircut. On the contrary, in a case which I dealt with while in Kolkata, Binani Cement and other cases relating to MBL infrastructure, they yield 0 haircut. Although there are a number of other factors which need consideration for effective implementation of IBC to achieve the object, they include timely appointments of members. We cannot stop parties raising number of legal points during CIRP, but the pleadings which now run in thousands of pages need to be curtailed so as to save time and energy. So these are my some of suggestions. I now throw this topic for discussion to my honorable panel members. Thank you very much.
So thank you very much for your keynote address. It is my pleasure, sir, to moderate the session in relation to some of the topics that are relevant and contemporaneous with 3 expert bankers who are on the panel. And I might fill in and add some of the industry perspectives if need be. So let me first start with Mr. Mehta. So how do you see the introduction of the IBC in terms of the change in the behavior of debtors? When the SARFAESI was the law which was relied upon for recovery, and the old Sikh Industrial Companies Act was also in place, it was debtor in control and the process was not yielding recovery, and one of the reasons to bring in the IBC was to overcome the increasing NBAs. So how do you see the IBC working in relation to the behavioral change of the debtors?
Thank you, Shardul. And in fact, IBBI chairman in his opening remarks, he commented about the story, and I'd like to little bit elaborate on that. I think IBC is the most landmark reform in the financial sector after SARFAESI, which has really transformed the relationship between the debtor and the creditor and has culminated into a greater financial discipline, which is reflected into the present levels of NPA, which has gone down substantially after the introduction of the IBC. Gross level of NPA and net NPA levels are going down, because it's not only that the cases which are admitted, as rightly said by the chair of this panel, Gosaiji, that in fact a lot of cases, just because of the deterrent effect of the IBC, got resolved even before referring to the IBC, or even because there is a psychological impact that earlier there was a predetermined notion among the industry that they have a legal mechanism available. They may not lose their asset, like BIFR was providing them that window under the SICA. So they can continue with the asset, they can continue to manage till last, and even at the last resort, we will be able to strip out the assets and then nothing can be transferred. But this IBC brought this psychological change in the mindset of the corporate that yes, with the introduction of 29A, now the assets can transfer, and some of the largest first 12 cases referred by RBI, if you see the fate, the value that the banking system has realized was much more which was on the table. Without quoting the name, my few of the banker friends are there. Like before going to the IBC, we were getting some restructuring proposal which was half of the value of the outstanding loan, or we were getting a compromise proposal which was half of the lending value. And some of these cases we could realize 86% or 90% or 100%. So that has shown two things. One thing, a financial discipline. Another thing, a greater value realization. And the third important thing is creating an ecosystem where alternative management options are available for running of the unit. So some of the resolution professional has done exceedingly well. Even during the period of resolution, the EBITDA contribution by those companies were more than what they was in the hands of the original promoter. So many of the groups like whatsoever was run by the original promoter, so whatsoever sales and earnings they were making during their time, some of the projects got a better earning when they were managed by the single principal proposition with the help of the advisors. So it's a definite, a very important legislation which has changed the landscape of banking and brought a lot of financial discipline to the financial sector. Having said so, as rightly said, every sector needs a reform, and when there is something new and any new law, one thing I must appreciate is IBC is a very dynamic law which has got within a short span of 6 years, it got 5 6 amendment. I think that is something very rare, and every amendment has brought a greater clarity into the interpretation, a greater clarity into the financial ecosystem, right from waterfall mechanism to the authority of the committee of creditors to the 29A role of the existing promoter. So all these things have really given a new dimension to the IBC. But now a time has come. I think we need to review some of the loopholes, and I must appreciate that this initiative of IBBI and Chairman IBBI recently held a meeting with the bankers, and this was thought that yes, there are delays in admission, how do we address them? Why can't we have a standardized documented template? And Mithal Saab took a personal initiative and interacted with the bankers themselves. What are the problems you face? What are the common questions you face before admission? And so they said, we have to establish the debt, but can it be done by the information utility? Can it be done by some information provided by the debtor? So all these issues clearly indicate the positive and contributing role of the IBBI in redefining the rules, regulation, as well as necessary amendments that will take it to the next level. And the pre-pack, once although it's an infant stage in MSME, and if it is also introduced to the main course, all type of corporate debtors, this will be a game changer. This will reduce the burden of NCLTs because capacity is needed. Another thing is the speed. As rightly said, the value goes down with the passage of time, so that will get reduced because the resolutions will be worked out, and the time frame is only 120 days, out of which 30 days only there with the NCLT to approve that, and 90 days is available for the committee of the creditors to take a final call on the plan. And there, especially post-pandemic cases where there are genuine default in the sense that reasons beyond the control of the promoter, because the hospitality industry, suppose 2 years they were in a lockdown, the cash flows were impacted and they could not service, then at least such type of people can get relief in case there's a pre-package implemented. So overall, as a representing banking body, I can say this is the most important legislative reform which the government and IBBI has very aptly managed it. And today's conference is an indication that we are all ready and accepting the changes which we need to bring to make it more efficient for the entire ecosystem, including all the stakeholders. And thank you for this support.
Thank you. So I would like to ask Mr. Sriram a question in the context of Section 29A of the IBC. So would you be aware of the reasons why this was introduced at the time when the SR case was under consideration, and what was the moral dilemma that was being faced by the bankers, and was the intervention really pushed by the resolution in the matter of SR, or do you feel it was a amendment which was waiting to happen?
Yeah, thank you, Mr. Shroff. That is the problem when you have people like Mr. Shroff as moderator. They will ask you uncomfortable questions at the right time. And on top of it, we have a chair as educating authority. So we can't, as bankers, we have a problem with that as well. But being a former banker, I can only request his indulgence on contempt of court and continue with whatever I have to say. To add to what Mr. Mehta said, if you give me some indulgence, I'd like to ask, put in perspective a little more on the behavioral issue from the perspective, not from the perspective of the promoters and so on, but from the perspective of bankers. There are 4 basic areas that were not there earlier, and which the IBC has actually turned around for banks. The first, as all of you know, is the creditors in control. Now, creditors in control doesn't mean, as many of us feel, that creditors are in power. I would like to make a little bit of a sort of a distinction there, that it is creditors are accountable and responsible to get a resolution in the interest of all stakeholders. So it is not that creditors in power and they will go everything to liquidation. So that is one thing, and that is something that has been a clear change in behavior from what it was prior to IBC to what it is today. The second one is that the creditors had always been looking to the promoters for any resolution. So looking beyond promoters was something that IBC gave, and I think one of the clear-cut cases was the SR case, which Mr. Shroff is pointing out. So looking beyond promoters for a solution in terms of demand supply of the asset of the corporate debtor or the corporate debt that is there and so on was something that was not available, and the behavioral change started to happen on the creditor side. The third important aspect was haircut. Many of us have spoken about haircut since the early morning today. The problem with if you go back in time and talk about the CDR process and so on, the CDR process actually was a resolution process with no haircut. Everything was recompense. Everything was usurious rates of interest and so on. So it made ab initio a resolution possible, viable in the short term, but impossible, uncomfortable in the longer term, because everything was coming back to the creditors as part of recompense or whatever you may call it. So in that sense, this was, there were a few other things, resolutions, regulations that came from RBI by way of various schemes, but a holistic redressal of this issue with the comfort of the adjudicating authority was available only through the IBC process, and that was a high behavioral change that I don't mind if there are demand supply issues or the market feels that the asset is not worth a certain thing, but I will find a resolution to protect employment, to protect capital, to protect credit, and to make sure that and as IAM director was saying, to finally, if there is a good resolution, the equity holders who stand behind it will tend to gain. And that, several examples you have seen, actually it has come reverse in the sense that why equity holders are getting more benefit today when there is a resolution process, whereas the creditors have actually got a haircut. So there is a problem there. I would imagine that there needs to be. And the last one is a very landmark decision, I think very landmark behavioral change, is that as bankers, as creditors, we always felt that we do all the work, all the dirty work you can say, and at the end of it, the income tax or the sales tax people will come and take away everything. So a landmark decision that government and state dues will be at the bottom of the pyramid, and they will not take in anything, even if it's under liquidation waterfall or a resolution waterfall. And that is something that is a huge behavioral change, a huge plus for us. Now coming to 29A, I would imagine, I think there is enough written about 29A in the public domain. There are various pros and cons in many ways, but the basic issue of a 29A to my mind, and I'm speaking for myself here, is that if there is a proven issue in respect of a certain management to run the company along profitable commercial lines, taking the interests of all the stakeholders into account. I think that promoter should step down and give a chance to somebody else who would be able to take care better. That is the crux of the matter. There have been various other issues, which could be involved with the 29A decision making. But clearly the SR matter, I think Mr. Mehta also referred to it, in the sense that the restructuring where it is only a one-party bilateral negotiation that goes on between a promoter and I did mention about behavioral changes, that we don't go outside the canvas, we don't go outside the circle to find out what is the nature of interest for such debt, which will give you more value, and find a possible solution outside of it. I think that power or responsibility, as I say, was given to us, and that is why the creditors, it came in as a big bonus to the creditors. And the fact of the matter again is, if you can go back and read these statements, that as soon as there was a good offer for 100% or close to that, the existing promoter also came out to that. So you can see the benefit of going through with a certain resolution, which was very well thought out.
I think I'll just like to supplement, sir, for a small addition, that Section 29 came in the midst of the SR matter, and the government was conscious of the fact that an asset which may be valued at over 50,000 crores was attempted to be taken off at the sum of 7,500 crores. And the parliamentary debate around 29A was clear. It came in the amendment to the section came in the midst of the matter, and the debates between Arun Jaitley, the law minister at that time, and the finance minister, and Mr. Chidambaram as the opposition leader, shows that the consciousness of the parliament was that you should not allow promoters to take the benefit of their own wrongdoing, especially when several of the bankers are in the public sector field, and the monies which are in the public sector are taxpayers' monies, and therefore the concept of really intervening and disqualifying promoters who have led to the insolvency situation came about. This was also one of the critical cases where backdoor means were attempted by SR by putting up another company effectively to bid in the process, and the early decision of the tribunal resulted and the COC resulted in disengaging the put up bidder and disqualifying that bidder. So 29A is demonstrative of the fact that it is the cause for the behavioral change, that you lose your management, you lose your ability to manage elsewhere in the situation where insolvency is attracted. You are unable to bid for any of the further insolvency situations where you feel that you will have an opportunity to participate. So it's a serious disability which has been visited upon the industrial community, and that is what is causing the behavioral change. If you see the conduct before the amendment of Section 29A, there was no fear as was introduced by 29A because of these three disqualifications that were visited upon them. The disqualification was not only to the owners but also to the managers who were responsible for the insolvency circumstances which came into being. So after dealing with the inception, I think one particular question which I'd like to ask all three of you is that how do you see the delay in terms of admission processes? Because there is a current paper on this very current paper from IBBI on this question of resolving delays in admissions. If it is a recognized statement that valuations fall during the course of delay and there is a deterioration or decay in the assets and their utilization in future for a new incumbent is not as much as the person in control of the enterprise. Having said that, why should there not be a better process of admissions, and what do you think would be such a better process? Mr. Mehta. Excuse me. I think no, they shut them all. Can you just check it?
So I think it's a very relevant point, and as it was deliberated in the opening session, and when Chairman IBC raised this issue, that inordinate delays, like more than the resolution period time is spent in admission, that is up to 700 days, it's a cause of concern, because this was also deliberated that if it is delayed in admission, during the course of time, there can be asset stripping, there can be further deterioration in value, and there can be loss of interest by all the stakeholders, because beyond a particular point, if the company deteriorates, there are no resolution applicants available in the market to take over those assets. So it directly or indirectly impact all the stakeholders, because ultimately it's the employees whose interests are also protected if it is taken over in time when it's a running unit, or it is an interest of the government also, because if it's a running unit, it is producing something, government is getting some taxes on it, maybe on the sales, that is also protected. And the financial creditors, definitely their interest, because early resolution will bring. So one good initiative that has been taken by IBBI is how to plug these loopholes. And one of the questions that was raised in the meeting by IBBI chairman to the banker is, can we standardize the document for filing a application? And if that can be done, can we create a checklist where all necessary documents which are necessary for admission can be put up right at the time of filing itself, so that the judicial process of validating the debt is done through the documents available on Zoom. And there are information utility level, like NESL is available, whose the data can be relied upon, because that's an information utility created by the IBBI. And there can be acknowledgement of debts, there can be other important documents which can say that yes, the borrower himself has acknowledged the debt, so there is no need of fresh validation of the same. So similar type of checklist if can be created, and documents can be improved, and I think that's a very good suggestion which can reduce the substantial time for admission of the cases. And the other factors is sometimes as a banker also we miss out in the process of filing a case in hurry. We do not provide the substantial documents, and then we say the cases are not admitted. So somewhere the checklist and the matter will say that if you have to file an application, it has to be with a certain checklist completed, and then only it will be treated as a proper application filed, and then only the 14 days period will start for admission. Automatically this will resolve some of the issues. I think it's a work in progress and need of the hour, and rightly being deliberated, and today researchers are there, so if they have some better suggestions to offer, I think the banking system will be too happy to do that.
Can I come in here, Mr. Shroff? So, Mr. Shroff, the question that you asked had two parts. One is the protracted nature of the admission process. The other is attrition of business value. Honorable panelist has already spoken about the first part, the protracted nature. I would like to dwell a little about the attrition of business value. Now, the attrition of business value indeed happens if the admission process gets protracted. But we all know that businesses operate in a dynamic environment. It's not that when a case is referred to NCLT for its admission, that is the point in time when the attrition of value starts. Actually, attrition of value starts much ahead, much before that, because we are all aware of the volatile nature in which businesses operate. So I think this is one aspect which RBI Deputy Governor in his speech also alluded to, that see, the efficacy of IBC actually works outside the CIRP process. I would like to bring in a distinction between IBC code, a subtle distinction, a nuanced distinction between the IBC code and its influence and the CIRP process itself. Now, there is no gainsaying the fact that the CIRP process by itself has had a tremendous and enormous beneficial impact on the credit market in India. And a quick and the best way to, I think, assess that is to look back into the period when we didn't have the IBC code. And we know how it has been successful, the CIRP process. But I would say that the IBC code has a much overarching influence on the credit markets in India. Just by its sheer existence, it drives many aspects of the borrower-creditor relationship, and also I would say many aspects of keeping a business viable and sustainable. It's not just, I would say, the borrower-creditor relationship. It has got profound influence on maintaining a business as a sustainable and viable business, which is the objective of all stakeholders, not just the creditors, even the shareholders. So to that extent, I think I would say that I am seeing a more readiness, a more fleet-footedness, if I may use that word, between the borrower and the creditors to take and resolve issues upfront, issues facing business. Ideally, when does a business starts, making defaults? I think it starts, defaults can be, of course, first of all, of various types. Not all defaults are because the business has, lost its significance, or there's something wrong with the strategy or the operating model. Sometimes default could be because of a simple working capital issue, which is a temporary, one-quarter issue. I'm not referring to that. I'm referring to defaults which emanate out of much deep-rooted issues in the business model, I would say, or the business affairs of the company. In those situations, because of the existence of the IBC code, because we all know as market participants that here is a code which will ultimately dispose of this issue, I think all the participants, it's a great platform for all the participants to come together and treat those issues, tackle those issues head on, which might require reorganization, restructuring, because all defaults are not because of problems in the balance sheet. Here again, we have to distinguish between problems in the balance sheet and problems in the P&L. When I say problems in the balance sheet, I'm actually referring to the capital structure. And when I'm talking about problems in the P&L, I'm referring to the operating part of the business, the EBITDA generation.
May I intervene? Our question was limited to the issue of what should be done for faster admission. Yours is a more long-term perspective on how insolvency or incipient problems in relation to the functioning of companies which are sort of struggling to keep up in terms of their credit worthiness and in terms of their continued employment, all those questions. So my question was on the limited issue as to whether, with the knowledge that there is a declining value, with the knowledge that the errant promoter is in control, till such time as you admit the petition and till such time as an interim resolution professional is appointed, what should be the urgency or what should be the method of change in the IBC? Is this a more mechanical process? Should it be done on a templatized basis? Should there be just a verification bound factor? Should it be like a computerized system rather than a application by judges, NCLT? Because if you look at it from the perspective, and if IBBI's view is correct, that it is a templatized process and it requires essential filings, this can be done by artificial intelligence. This can be done by proper, system management, machine learning. There could be so many other ways. But the real problem is not that. The real problem is that because of the judgments of the Supreme Court, natural justice has been welded into the admission process. Natural justice would mean a hearing before admission. And I have known of cases where 6 months have been taken in just admission, which is unpardonable. You have 6 months to close the CIRP, and instead you're taking 6 months to just admit a petition because you raise issues of counterclaim, you raise issues of documents are barred. I think the remedy lies in specifying the kind of natural justice that you are eligible to at the commencement of the process. It is natural justice does not mean everything to everybody. Natural justice can be molded to the specific circumstances of the case, and it need not, just because the status of a company is affected and the status of promoters is affected, you don't need to give a 6 months hearing in relation to admission. The issue to be tackled is not process bound. The issue to be tackled is how do you save judicial time in relation to all these other issues which are raised in defense by the corporate debt. So this is the question that we pose to the presenters. This is the question that the research papers should really address. And my own feeling is that while artificial intelligence and machine processes can really come up with the answer that yes, the petition is admissible, this issue of natural justice is the cause of delay and must be addressed on a war footing as to limiting the right of natural justice. Because if you start getting into a civil suit process in a summary proceeding where admission has to be done in 14 days effectively, this is a never-ending process. We spent 180 days. I am aware, I was in that case in the Punjab Chandigarh tribunal, and merrily it went on for 6 months. I have given the details to IBBI that there are instances where this is happening. Either it doesn't get listed because of the pressures of time in the NCLT, or upon admission, I mean, if it's brought up on board, it is dragged incredibly on the grounds that there are counterclaims and this is not correct. The behavior of parties, bankers has resulted in my loss, and all sorts of defenses which are untenable.
May I defend myself to some extent? Because it is directly retained. No. No, not blame. This is not a blame game. It's all right, artificial intelligence, everything is very appreciable. Yeah. But my point is something different. Yes. We sit in an adjudicating authority. Section 5 of IBC defines what does the adjudicating authority means. It is an NCLT established under 408 of IBC. When we speak about optimum use of infrastructure, and chairperson is here, IBBI chairperson, we must put our suggestion to him also. Why they require 2 judges to decide admission? Section 7, nothing is there. Where there is a default and whether matter is within limitation, claim is within limitation. These are only 2 issues. In section 9, we decide whether there is a debt, whether there is a default, whether there is a pre-existing dispute and limitation. So it is very easy. But problem is that we engage 2 brains to decide this simple fact. Let us make a suggestion to the government. Adjudicating authority definition should be amended to extend that it is not NCLT. Adjudicating authority appointed under Insolvency and Bankruptcy Code. Let some arrangement should be made. We are 100 judges. We sit in 2, so we 50. We get 100 judges at the same time, maximizing the infrastructure utility. That can be done also.
Mr. Shroff, sorry for cutting in. May I complete my point?
I'll bring it up in sequence.
Okay.
I'll bring it up in sequence because otherwise we have got maybe half an hour to finish. That's the mandate given to me to finish by 1. Whilst your suggestion, sir, is very welcome, there are parallel processes which I may just touch upon. That the Honorable Supreme Court has this kind of process, where a single judge or the registrar has been given processes of adjudication, where admissions which are of a miscellaneous nature need not go to a division bench unless there are serious questions of law. So you can clearly bring this suggestion within the framework of the IBC, because to admit and take 6 months process of valuable judicial time is criminal.
Can I take a minute?
Yes, sir.
No, one of the things that I've written down is feedback from Adjudicating Authority for Natural Justice. There are 2 things. One, as he said, if there can be a shortened, or rather a shortened bench of one adjudicating authority to decide on that. I would also suggest, I don't know whether it is still happening, a dedicated time during a week for admissions, for these particular cases, so that they can go on fast track. So that it, the admission goes on, and then of course the other things take the 330 days issue there. Also, the question of, I don't know how the natural justice pans out for operational creditors. I think that is something that, we are talking about financial creditors generally. For operational creditors, what is it that the adjudicating authorities look at? And that sort of feedback can be built into a sort of a
So that is
process
also
that is
pretty
there.
well known for the reason that it is subject to creation of a template. I don't think the process for admission of operational creditors is significantly different
No.
from
I'm not talking about the template for application.
Yeah.
I'm talking about the feedback that can come from the adjudicating authority. That could be done by way of a template as well.
So just advancing the process, there is a thought which has been conveyed to me by the IBBI that there could be some issues which, as a part of like an advanced ruling authority, could be referred to the IBBI, where instead of, and of course that would mean that IBBI will be given powers of adjudication and conferring judgment, just like the advanced ruling authority has in relation to Income Tax Act. And some of the questions which are not requiring judicial time, as in the sense of the NCLT time, but which are part of the thinking and the research which has already been undergone, and for which there is sufficient background material which is currently being used in long drawn arguments in the tribunal. Can that be a process introduced? That is a suggestion which is there. I'm just leaving it for the thought of the bench. The next issue which I'll really like to take up is that in the process of conducting a CIRP, firstly, this whole theory that it is limited to professionals as in individuals and not professionals in terms of organization, and there are circulars in relation to that, is unrealistic for the simple reason that for a single man to accumulate all the assets, to run all those assets, to follow up on an information memorandum, to cause the to receive all the claims, to arrive at a complete statement of claim which is presented both in relation to secured, unsecured, and operational creditors. You're putting an insurmountable burden, and therefore leading to practices where the backup is really the accounting firm. Why would you not recognize this fact? Because most of the bankers who are involved in the larger disputes are clearly resorting to individuals backed up by an organization. So is this not a reality which should be recognized by IBBI? And I would seek your suggestions, Partha, on this.
No, I would clearly say yes. In fact, I would say that, considering the size of assets that have gone through the IBC process, I think it does not give enough an adequate time, and it doesn't give adequate time for a prospective investor to do the due diligence and come to the real enterprise value that he or she would like to bid. So in fact, not only that the RP should be supported with a larger team, I would also recommend something akin to vendor DD that is done in typical M&A and private equity kind of transaction, to go all the way and support, because this will be a big support for the value discovery process, and this is obviously serving all the stakeholders, the corporate debtor, the creditor, and if there is a value for the equity holders in that bid, and the outgoing equity holders as well. So I would definitely recommend that, and even include vendor DD to be considered in the purview of this.
So in fact, a suggestion was given to the IBBI, and a suggestion was given to the Ministry of Corporate Affairs, that one should look at a shadow prospectus which is updated every 6 months or every quarter, and which has the responsibilities of a prospectus, because that scheme is now carried through under Section 77A for the purposes of enforcement and punishment. So it is impossible to sit and collect evidence and data and to make a data room within the time frames prescribed for an RP to really present this information and to come up with a PIM or an information memorandum. So the suggestion which Partha gives that there is a need to have better due diligence can only be met if there is a prior process put in place where the company is not even in an insolvent process, but at a process where it has got the wherewithals to keep updated the preliminary information memorandum, which can then be updated in the short time that is available to the RP once he is IRP once he is appointed. So, and the reason is that if you speak to any of the merchant bankers, they have always come forth with the theory that unless there is full disclosure, you will not get proper value. This is a constant theme anywhere you go, whether we've traveled with IBBI to Singapore, to US, and this has been the constant refrain that you give too little information, too less accurate information, and therefore you cannot achieve maximization of value. Now, contrast this, sir, with a situation of what the learned member mentioned in relation to Binani cement, or for that matter, any company where there is natural resource which is of limited quantity and where there is a great deal of competition to acquire those assets, even if the company is not a going concern. So the realization of 100% of the value of the creditors or the operational creditors was as a result of open competition in the court. It was not an open competition through the system of CIRP. It was a Swiss auction actually happening without the features of a Swiss auction in the court. And it violated many principles, for example, that can you, for after the closure of the bidding, can you introduce a new bidder? Can you permit changes in a bid which has already been made? So there were many issues, but I think the main issue which sort of prevailed on the court was that I am realizing 100%, I am achieving my goal, which is part of my preamble, maximization of value, and therefore they overturned the decision of the COC. The winner was actually one who had lost, and the lost bidder really became the winner in the process. So there are several aspects in the Binani case which will never repeat themselves for the simple reason that the law has progressed and the law has covered each of these issues. There are Supreme Court judgments now on each of these points. And one needs to only point out that this is not permissible under the CRP. Early days it happened, but it will repeatedly happen when there is, it may be oil and gas, it may be limestone, or wherever the resources are few and there is a great competition among the large players in the industry to take this, because I think they also believe the fact that the Competition Commission does not go into the aspects of full competition, the way a full competition process is undertaken. They are under mandate to give the approval under 30 days. So the Form 2 kind of analysis that takes place if you have to go voluntarily does not take place because of the timeline mismatch between the IBC processes and the process which is required under the Competition Commission. So it is an advantage for them, the larger players, to go through BIFR because there is less scrutiny under the Competition Commission. So let me now take up one of the hot issues which has come up from the parliamentary committee. So this pertains to the code of conduct, and you have now a IBBI paper also describing the code of conduct, and Mr. Sriram, you have written in relation to the code of conduct. I have 3 observations and then I would like your reply. The code of conduct has ramifications in relation to public sector banks. It has impact in relation to private sector, private banking, where there is no element of state. The judgment in Escorts Limited still holds the feel that in a private contractual matter, I have the right to act as a private citizen, and I am not bound by the rigors of Article 14 in a contractual matter on a pre-contractual stage? How would you equate the principles between private bankers and public sector by a single code of conduct when they may have commercial reasons to decide in one way or the other? They may not, for example, trust the promoter. They feel that he is not a clean and honest promoter, and therefore they want to get on with the task and find a buyer at a higher haircut. Per se is 95% bad, because there are several cases in which, I mean, it's not just the Videocon case, there are several cases where there are more than, I mean, about 95, 96% haircut. So is the principle only going to be decided on the basis of the extent of the haircut? Or are there other rules in relation to the code of conduct? Would you, for example, introduce aspects of how the committee of creditors plays a role of a constructive trustee with reference to other stakeholders? How does it look after the interests of operational creditors? How does it respect the inter se priority between creditors? It's not one class. I think several judgments of the tribunals and the NCLAT proceed on the footing that all secured creditors are one class with equal rights, which is completely wrong, because there are priorities which have been fixed under the register of charges, and it has to be distinguished as to who is going to get first or not. You may have a single priority with reference to entry into the committee of creditors, but when it comes to distribution under 53, each one has his or her own priority. How are you going to weld all this into a code of conduct? Because there are dissimilar elements. It's not like writing a code for an RP or for that matter, I mean, any of the intermediaries which are regulated by IBBI. A committee of creditors is actually within the domain of the RBI. And you are asking the IBC to really prepare a code of conduct in relation to creditors who are mainly creditors dealt with by the RBI. Of course, the unsecured financial creditors could be anyone, need not be regulated by the RBI. So there are very complex questions in relation to code of conduct of creditors. And so, because you've written a paper, I would like to hear your view.
No, thank you. I was sort of expecting this question, because having written something, I would imagine that you will find holes in it and try and. Thank you for that. So you see, the fact of the matter is between private and public banking and so on, what I see is that the committee of creditors is only one. There is no distinction between what type of creditors sit in the committee of creditors. They're all financial creditors who have given space, and all the representation from everybody who has given debt or financial debt is represented in the committee of the creditors. So obviously the alignment of all the committee of creditors is upmost. And in many cases we have said majority, some cases 2/3, 3/4. And at section 12A says 90% and so on. So alignment of interests have to be there with every stakeholder within the committee of creditors, irrespective of whether they are regulated or they are outside the regulation thing. I've sort of mentioned it as also in the article that there are many jurisdictions which don't have this committee of creditors, but work in a similar way, like for example a judicial manager or an administrator or so on, but that is more a judicial function rather than a committee of creditors structure here, where, as I said and I repeat myself, that the committee of creditors should not be powerful, but should be highly responsible and accountable to what decisions that they are saying. There are 5 principles that I feel very strongly in terms of what the committee of creditors should do as part of the code of conduct. There's a list that I've suggested. There can be a list that anybody else can suggest what are there. But largely the point remains that it has to be voluntary, that voluntary code of conduct adopted by the committee of creditors. It cannot be mandated. Once you have mandated code of conduct, then people will will approach the adjudicating authority for everything and everything. So that is very clear there that there is a discipline that needs to evolve, a sort of a code of conduct that needs to be voluntarily adopted by the committee of creditors. And in what way? And it's not going to come overnight. This is an indicative list of things that people can do, and over time, maybe 5 years, 10 years, it can evolve. First is the suitability to drive the resolution process without conflict of interest. Now, that is very clear that if there is any conflict of interest between people sitting on the committee of creditors and outside in terms of becoming a resolution applicant and so on, that is something very, very, very critical. And that is a very, even if the code of conduct is not there, I think it's expected of anybody and everybody who sits in the committee to be aware of that. Second, and as I said, coming from the responsibility point of view, act in the best interests of all stakeholders. Now, there have been cases where we have protected financial creditors, we have not protected operational creditors. There have been various other things that have happened where the interests of some stakeholders are perceived that they have not been adequately taken care of. And this is again going to be driven by outcomes in terms of how these pan out and how you want to change yourself on that. Third is, of course, to act in, this is a very generous statement that we have, act in good faith, fairly and honorably, and be seen as independent and impartial. So the committee of creditors being independent and impartial has to be very clearly driven. The fourth point is very important, and this comes to the commercial judgment that Mr. Shroff is talking about. We must make sure that we exercise good commercial judgment. And for that, if you need external support, you need external validation of what commercial judgment you have taken, and maybe recording those commercial judgments in black and white to make sure that at that particular, because any commercial judgment is applicable only as on that particular day and time. 5 years hence, you can always come back and say this was wrong. But clearly there is, so the recording of what sort of commercial judgment and what side and how you have done and aligning with all the stakeholders is very important. And finally, it has to be feasible, it has to be compliant with laws, and fair and equitable. I think these are the broad guidelines in which a committee, a code can be driven. And you can put in various points on the code of conduct depending on what you want to do or not. You can even make it stage-wise, that these are the first 5 points that we want to do as a code of conduct within, say, 6 months. Then take it along as we go ahead in that. But these are my thoughts on the code of conduct.
I think there are very critical points. Thank you, sir. The code as presently presented in the discussion paper has a lot of repetition and needs to be carefully scrutinized with these as the guiding principles, as Mr. Sriram has correctly said, because these are the overriding principles. I have just exercised one area of caution considering how we are a major litigious society, that if you start recording reasons in a judgment, then those reasons will become justiciable. And instead of actually getting yourself into the resolution of companies, you will get into the questions of justifying that reason on principles of equality and all sorts of constitutional principles. So the rule in escorts is a rule which you should follow. As long as reasons exist on the file, they need not be reasons stated in the decision order. The judiciary can always see the reasons, but the judiciary cannot get into causing a dispute in relation to the reason and causing an adjudication thereof, because that is an enormously time-consuming process and brings in all the issues of private banks don't need to give reasons. So why would you tag the reason given? And that was exactly the rule in escorts. The argument was that it is state, LIC is state, and therefore it has to give reasons. But that was rejected by a bench of 5 judges. I have a lot of points, but let me restrict myself, sir. There's a last point which I'd like to raise, and that is in connection with the preferential transactions or transactions which need to be avoided, and the consequences of the 2 Delhi judgments wherein the court has held that upon the uh, completion of a CIRP process, there is no right to continue those the applications for avoidance of those transactions because the way the law has been. I have a serious concern in relation to that because the law necessitates that you track the wrongdoer. To say that just because a CRP has closed, now there is no jurisdiction in the NCLT and everything is over, and the RP is bidding on the principles that there is no recovery or there is no need to adjudicate on the avoidance and the preferential transactions, in my view, is giving up a very major aspect of punishing the wrongdoer. So if the judgment as is presented by Justice Pratibha Singh is considered, I think it is important to really carve out this rule, and for 2-3 reasons. If you see the Companies Act, there is a power under the Companies Act, independent of the IBC, to prosecute a person who's a wrongdoer. There are enough processes, both under the scheme of reconstruction, reorganization, or arrangement, where the rules and the act itself contemplate that the procedures in liquidation can be brought into the CRP, and you can therefore proceed against a wrongdoer, which is a continuing process. Ultimately, what must be looked at is that malfeasance, misfeasance, omission to do are public injuries, are public wrongs. They are wrongs against the state. And therefore, to say that the RP does not have jurisdiction or that the NCLT has no jurisdiction is wrong. These are crimes. These are matters which fall within the special jurisdiction of the NCLT and must be carried through, irrespective of the fact that the CRP has. It's only a question of deciding who will get the benefit of it. Should it go to the state? Should it go to the creditors? Should it go to the company? Some of these principles are well known in law, but to let off the wrongdoers is I think, really wrong, and I would recommend that this be relooked at.
I suppose there is a section 26 in Insolvency and Bankruptcy Code, which was not brought before notice of Honorable High Court. It has been discussed. But then how it is interpreted, I don't know, because 26 is very clear. Irrespective of CIRP is closed, these applications for preferential external transaction can go now. But on what ground, I don't know. I don't know. But there is a provision in IBC.
So with that, I've got another 10 minutes. So despite the chit that I must finish, I would like to ask some of the questions from the audience, if there are, because we've been only asking questions on the panel. If there are any questions from the audience, I would most happily. Can you just give the gentleman in the first row and then in the second one?
All right.
Okay, the other way.
Hi,
I think he's. Okay, you ask.
All right. My name is Dushyant Dave. I'm IP from Mumbai. Similar to the question about admission, can there be a mechanical process about the assets which are attached by the ED when the CRP takes place? And we find that thousands of crores of assets get attached and then just they get rotten and nothing happens. And there is no provision. So it has always said the IBC precedes over this, but in PML Act itself there is no provision. As a result, there's always a, and whenever we approach the bench, I think there is a gross delay. So can there be either an amendment in the Act or an automatic, the moment the CRP starts, the assets then belong to the creditors? The criminal process can continue with the ED or CBIs. Thank you.
I think Mrs. Swaminathan, you wanted to raise.
I am Jaidev from IIM Bangalore. In spite of constitutional validity of the IBC, there are some cases where borrowers have approached the high courts and obtained the stay. In the case of one of the Reliance Anil Ambani group companies, Bombay High Court has given the stay. Similarly, in Telangana High Court also has given some stay regarding 2 or 3 borrowers not approaching the bank to take the appropriate action. So is there any way that these high court judgments can be overcome and bank can proceed with the CIRP processes?
I think the question of the High Court interfering when there is an appellate remedy, part of the IBC has a natural appellate tribunal, and the courts have consistently held that when there is a tribunal which is to look at appealing issues, the High Court in its special writ jurisdiction should not interfere. But ultimately, the judges are judges, so they sometimes feel, oh, there's a growth. Yeah, absolutely. No, I'm not meaning, so you're taking it personally. That being said, so yes, you could go up in appeal that the order of admission is wrong and set out the principles where the courts have itself held that you should not interfere in the continuing process of CRP. And I think in the Supreme Court, you'll get a reversal, but except that you'll have to follow the procedure prescribed by law. Mr. Swaminathan, if you wanted to.
There's one, the public commentary as well as the many speakers today was on the haircut. So I have a couple of thoughts and I would like to hear the panel's view on that. Number one, see, the alternate forms of recovery can be a civil money suit or a SURFACE DRT-led proceedings. I may have a recovery certificate or a decree for the total debt that is due. But however, when an execution stage is entered and recovery has to occur, recovery is going to be equivalent to that of the underlying asset or the enterprise value. And I may end up recovering maybe 20 cents or 30 cents per dollar. But then there has never been a criticism of holding a recovery certificate which is 100 rupees but in recovery of 20 rupees. We were not much worried about that. The second aspect is that also was alluded to by the Honorable Member NCLT in his keynote before the panel, is that should we examine the commercial wisdom of COC, should NCLT take on record whether it has been properly assessed, appraised, whether the resolution plan presented that is correct or not. Do we want NCLT to get into a judgmental opinion on the commercial wisdom of NCLT? In case if that happens, will it probably result in resolution plans getting rejected, and which obviously will lead into only liquidation, nothing else. And the third and the foremost is the principal objective of IBC. Are we transgressing on that in terms of the principal objective being a resolution? Recovery is incidental. We would like to have an orderly closure to a corporate which is in stress. That is how the IBC started. But in the last couple of years, even NCLT is making remark like, this is not a haircut, it is a tonsure or a total shave kind of observations coming from the benches. Is it likely to impact the ability of COC in taking certain bold decisions of accepting resolution plans? Is that something that IBBI or the government can build a narrative that the objective of IBC is the resolution and recovery is incidental? Well, of course, it may be a difficult pill to swallow, but in case we don't build a counter narrative, the narrative on haircut is likely to impact is the fear of the lenders.
So if I may answer from the last question backwards, the basic premise of resolution is that there must be viability, sustainability, in the sense that you will not accept a plan which does not result in a continuous ability to keep the organization running. If as a banker, as a process of evaluation, you evaluate the application for resolution plan which is presented to you as a COC, you come to the conclusion that this is unviable, then it is not for the court to substitute its decision because you are the expert. And that is exactly why it has been held that the commercial judgment of the creditors is the paramount principle. Because it's not, I don't like your face kind of argument, but it's based upon the principle that a resolution needs to have commercial viability. It must be able to sustain itself in the future. And for aiding it to sustain itself in the future, you can give haircuts, you can give all sorts of reliefs which are permissible when a resolution plan is made. So the fundamental rule of what has been held by the Supreme Court of India is not going to change, because the Supreme Court in several cases has held that in a domain of an expert, the court has no business to enter. Because this is not, it's not their science, it is a science of the banking industry to determine what is viable or what is not, because nobody's going to put good money after bad money. That is one. The second principle which you raised, sir, was this whole aspect of reasons. Now, in my perspective, and I may be wrong, putting reasons only creates the opportunity for adjudicating the reasons, whether the reason is right or the reason is wrong. And that will bring its own protracted delays, which unfortunately the NCLT will have to decide. They cannot say that now that this issue has arisen and there's a serious question of law on the constitutionality of the COC's action, and this is majority owned and majority managed by public sector banks, so I want to go into the reason. It will be an endless process. And this whole 330-day time limit is just non-existent then. One might as well forget the principle that there are timelines in the IBC. If we open the Pandora's box of reason and the whole principle of equality, it will be a disaster in many ways. So the recommendation is that you must have a reason on file, but that is not the reason which you need to communicate, because the fact that you have not acted arbitrarily will be provable by your document on file. This is exactly what happened in escorts. In escorts, Mr. D.N. Davar, then the chairman of IFCI, had put a reason and tendered it at the board, which was a hostile board. 9 directors of that board were replaced by LIC through a requisition. But he recorded the reasons in a slip that he gave at the time of the meeting. That was never referred to as a part of the reason, and they attacked it on the ground that this is unreasonable, that this thing. When the matter went to the Supreme Court, on the basis of the affidavit of IFCI, said that yes, there were reasons given on file, there was a reason given by the chairman of IFCI, and that reason is good enough. We will not interfere. This is not as if they have acted arbitrarily. They had a good reason which he recorded in the meeting. And that's all. That reason was not the basis of the decision to throw out 9 directors. So I think that is good law, because that's why I said the contours of natural justice, which is what is plaguing the NCLT, must be either judicially decided or legislatively decided by the IBBI, that this is the contour, because natural justice is an unruly horse. It means many things in many times. So it is for them to prescribe what natural justice is, so that it could be documentary, it could be post-decisional hearing. There are so many judgments on natural justice that you could have a view that this is the kind of natural justice that will be looked into. It may be without a hearing. Why oral hearing for natural justice? There is no necessity in law as a part of the natural justice rule that you must be heard. So there has to be a management of this aspect, because the delay effectively at the stage of admission especially is because of this whole, the courts are duty bound to give a good hearing. And that's what's taking time. Yes, please. So, Mr. Onikrishnan.
I have a layman's
Just
question.
1 minute. I think he will. Give him one.
See, you were talking about that one informal set of decisions without the matter going to NCLT and then getting decided. Are you talking about a decision by IBBI? Because IBBI is already having an informal mechanism for giving opinions on certain issues which are raised before it.
Yeah.
So IBBI regulation making rules or regulation making regulations.
Yeah.
The method of making regulations, it is brought in the form of a regulation, and that provides an informal mechanism for giving opinions on certain things, and it goes with a caveat that this is not rather adjudication of law. So is it that?
No, sir. I'll put the question which came to me from a IBBI person. The question reads like this: can the working of the IBBI be expanded to reduce the burden of the NCLT? The advance ruling option in case of transfer pricing issues under the Income Tax Act is an example. Can a similar model be used for the IBBI to handle certain identified issues under the code? There is a separate question also. The NCAR recently concluded an independent evaluation of the IBBI. As a regulator, how has the IBBI fared? What are the strengths and where lie the weaknesses which need further improvement or regulation? So the person who's formulated this question is aware that the power of regulation exists, but He wants to extend the principle of IBBI being an adjudicator of certain advance ruling issues which bind the parties, just like in an income tax advance ruling, and therefore don't spend the time of the tribunal effectively in raising those questions. It's a good suggestion, but it will require significant change in the IBC, and it will probably have to be deliberated upon by the Insolvency Law Committee. I think the gentleman here.
Sir, I have a layman's question. If the lenders are agreeable to taking 96% haircut, why would they not take 100% haircut?
Because they will be accountable to the CAG as to why they didn't do, why did they give a complete write-off of debt. No, it's not just 4%. It is employment, it is continuity, it's payment of taxes. There are lots of issues which go into the making of a decision. It's just not the fact that the lenders retained 4%. If the unit is closed, take a situation where the unit is closed, then effectively your money is lost unless you recover. Unless you go to the recovery tribunals, what are you going to recover from a unit which has no workmen, no licenses, just merely the assets, which are also depreciated? So there are justifications as to why. Yes, sir, please.
You see, haircut is not clear haircut in the sense that you take out 96% and take it, throw it away or something like that. There are various ways in which a structure has happened for a company that is under resolution. For example, the lender can convert it into equity, right? If the company is getting resolved, clearly there will be a benefit in terms of equity value when the company recovers and does better. There is something called taking debt which has got no interest. You're just protecting the capital. You're not putting interest, but I'm not doing away with 95% of my principal. I'm saying that this one will continue without interest. And one of the things that I said earlier was the CDR mechanism which says recompense and all of that. But here we are not talking about interest rate at all. Here we are saying after 5 years or 8 years or something, if the company recovers, then they can pay back just the principal at no interest. So these are all things that are built in to see whether a company can be saved, right? And if a company is saved, as Mr. Shroff says, there are various other people, stakeholders who benefit, including minority shareholders, including employees. If you see the Section 53 liquidation waterfall, the first person who's protected is the workman, and after that only the secured creditors come. So all of that needs to be taken into account for the benefit of the economy in such, I hope I have cleared something.
I just forgot to answer a question which he had raised. Just let me address that question. So the issue, one is that the law was amended to clarify that the ED and the PMLA effectively is subject to orders under the IBC. The IBC has paramountcy. But on a certain legal question as to whether it relates back, it's not retrospective, the matters are pending in the Supreme Court. The Supreme Court has heard this issue and will come out with the judgment. Depending on what judgment is received, the way, the technique which has been followed by the MCA and the IBBI is to amend the law so as to treat it as a clarification since inception. Yes, sir, please.
What happens is the day a person stops, so the day a person stops his installment, 90 days after that, the account becomes NPA. 90 days after that. When an account, I'm replying it from the banker side and not from IBBI side. Let me first clarify, okay? So 90 days after that, the account becomes NPA. Then what happens? The penal interest starts. Okay, a penal interest starts and a penalty starts. Now this goes on for about a year or so, and then the account is placed before the NCLT. So what happens if the principal is 100 rupees, and when the account goes to NCLT, when it is about to go to NCLT, what every banker does is to take this to the maximum so that when the claims are settled, I get more money. Okay, so this 100 rupees becomes, let's say, 250 rupees or 225 rupees. 100 rupees principal or whatever was there at the time when that promoter had stopped paying his installment, and the day it goes to NCLT, it is always more than 2 times and sometimes 2.5 times. That is so. Then what happens? The value of the asset is deteriorating every day. Now, when the registered valuer who's appointed by the COC does the valuation comes at, let's say, 40 rupees. Okay. When the bidding is done, by that time the value is not even 40 rupees. It is because one more year may have elapsed. So the value will not be 40 rupees. Maybe it is 30 rupees. Maybe it is something else. So now, how do you calculate the haircut? Should the haircut be calculated which should be the denominator? Should the principal be the denominator? Should the day the bank went to NCLT, should that be the denominator? Should the value arrived by the COC as a part of the valuation process, should that be used for haircut, and so on and so forth? So what is commonly done is, just to create a sensation, is to take the maximum value, which even the banker knows that it is not correct. I mean, I know that I have been part of them for several years, and I have sat in their boards. I know what. So even the banker knows that is not correct. So what is done? We take that value, and from that value, we take the lowest value which we get in a bid. So naturally it will be 95-96%. In a few cases, naturally it will be that. But अगर आप principal पे देखिए केवल principal outstanding, if you see the value at the time it goes to NCLT, and so on and so forth, you will get a much different figure. I mean, and what we have seen is the value that the valuer has given. This figure is always about 1.5 times that value. I mean, it is not that they are taking that kind of a haircut. One more thing. Even if the banker takes the full haircut, let us take the worst case, that the banker is taking the full haircut, but the company, someone buys that company. If someone buys that company, then over the next 5-10 years, he will create more value for the economy than the haircut taken by the bank. So I think it is more important for that company to be revived. That company will pay more taxes. The company will create more employment. The company will add more to the GDP. And yes, the banker has taken a haircut. And even if you had not gone to IBC, the banker would have taken the haircut. As the MD SBI rightly said, DRTs mein ya usme we get a certificate stating it is 100 rupees, but do we really get 100 rupees? The main problem with DRTs is court order is okay, but the recovery, actual recovery is an entirely different thing. I hope I have addressed.
Thank you for your intervention. May I, sir, now request Mr. Gosavi to sum up the discussions of today, and sort of after he finishes, we'll close the session, and we will reconvene in the seminar halls at 2:15.
In fact, there is nothing remains for concluding, but some behavioral changes. Mr. Mehta rightly said that it has come because most of the cases settled even prior to admission. Then Section 29A issue was discussed when Mr. Sriram very good suggestion that what about employment? My this thing will be, in fact, problem is interpretation of Section 29A. All right, promoter proven misappropriation, promoters should be barred because backdoor entry. What about their relatives? What about their distant relatives? Why they were brought in? That should be considered properly. Then delay in admission, we have spoken a lot about this. I may not this thing. Borrower, the next was discussed that dedicated time, as Mr. Parth has suggested, it should be done, and we have moved to our precedent that we'll deal IBC cases Monday, Tuesday, and Wednesday, and NCA that company cases Thursday, Friday. Model will be come out very soon. Then advance tax ruling, of course, deliberation is required because it has to be adjudicated upon by properly. There are a number of issues, but due to paucity of time, I conclude, but I feel that we have very fruitful discussion on the subject, and I declare that it is concluded now.
We thank our esteemed panel members for sharing their insightful thoughts and having an enriching discussion, bringing forth different perspectives on various issues in the insolvency landscape, which will certainly act as an input for policy changes. Ladies and gentlemen, may I now request Mr. Santosh Kumar Shukla, Executive Director IBBI, to present mementos to our esteemed panel members as a token of our gratitude and appreciation. May I request Shri M.B. Gosavi to kindly accept the memento. May I request Shri Sunil Mehta to kindly accept the memento. May I request Shri B. Shri Ram to kindly accept the memento. May I request Shri Shardul Shroff to kindly accept the memento. May I request Shri Partha De to kindly accept the memento. Thank you so much, sirs. Ladies and gentlemen, before we break for lunch, there is an important announcement. So after the lunch break, we will have presentation sessions, which will be held in 3 separate auditoriums. So one is this PP Gupta auditorium, second one is the seminar hall 1, and third is the seminar hall 2. So the list of presentations has been provided in the presentation kit, and you may join the hall as per the topic of your interest. And we have the copy of the newsletter published by the IBBI available at the registration desk, so you may kindly collect a copy for your records. And the presentation session will continue from 2:15 p.m. to 6 p.m. And from 6 p.m. we will have another workshop which is on data-driven insolvency research. So may I now request you to kindly join us for lunch at the IMDC dining hall on the ground floor and join us back at 2:15 p.m. Thank you.